In the year 621 BC, a man named Draco sat down in Athens and wrote laws so harsh, so brutal, that some historians suggest they might as well have been written in blood, not in ink. Punishments for stealing a cabbage? Death. For being in debt? Slavery. For nearly every offense imaginable? Death. The word draconian, a word we still use today, was born from that moment, from one man, one set of rules, one stone tablet. But here is a simple question that most people never ask. Who gave Draco the right to judge? Who decided that one human being could sit above all others and determine the fate of another? The answer stretches back further than Draco, further than Greece, further than any civilization most people have ever heard of. Today, we are going back to the very first court, the very first judge, and the moment that changed human society forever. Before courts, before judges, before any written law at all, there was only power. The strongest man in a village decided what was right, what was wrong, who got to live, who died. And that was not justice. That was fear. For hundreds of thousands of years, human beings settled disputes the only way they knew how: through strength, through elders, through ritual, and through revenge. But as populations grew, as farming replaced hunting, as cities replaced camps, chaos grew alongside them. You could not run a city on fistfights and guesswork. Something new had to be invented. That invention would emerge from the oldest civilization on Earth, and it would change everything. Around 3000 BC, in the river valleys of what is now Iraq, the Sumerians built something the world had never seen before: a system. They created written records, written contracts, and, crucially, written disputes that needed resolution. The earliest known court records in human history come from Sumerian cities like Nippur and Ur, dating back over 4,000 years. These were not just lists of rules. They were actual case files, evidence, witnesses, verdicts. Judges in ancient Sumer were called dikud, men of wisdom, often chosen from the temple because justice and the gods were inseparable. But it was a Babylonian king, ruling around 1750 BC, who would take all of this and make it permanent. His name was Hammurabi. The Code of Hammurabi is one of the most extraordinary artifacts in human history. Nearly 300 laws carved into a massive stone pillar for every citizen to see. It established wages, property rights, divorce law, adoption, medical malpractice, and yes, it gave us the principle you probably know as an eye for an eye. But what most people miss is that Hammurabi also established the idea of the presumption of innocence, that you were innocent until proven guilty. That concept did not start in America. It started in Babylon. In ancient Egypt, justice was not just a human affair. It was cosmic. It was divine. The Egyptians believed that when you died, your heart was weighed against the feather of Ma'at, the goddess of truth, balance, and justice. If your heart was heavy with sin, a creature called Amit would devour it. You would cease to exist. This belief had real consequences for the living. Egyptian courts were held under the concept of Ma'at, meaning every judgment had to be balanced. Every decision had to reflect universal truth, not personal preference. But it was the Greeks, specifically the Athenians, who made a revolutionary leap. They decided that justice should not belong to kings or gods or priests. It should belong to citizens. Around 500 BC, Athens created the dikasteria, the world's first jury system. Juries of up to 501 ordinary citizens, chosen by lottery, would hear cases and vote on verdicts. No judge told them what to decide. The people decided. And the most famous trial in history took place in exactly this system. In 399 BC, a man named Socrates stood before 501 Athenian jurors, accused of corrupting the youth and impiety toward the gods. He was found guilty, by a narrow margin, and sentenced to death by hemlock. The trial of Socrates became a turning point in the history of justice, proof that even the most sophisticated legal system could be weaponized by the powerful. It is a warning that still echoes today. If Athens invented the jury, Rome built the courthouse. The Romans were history's greatest legal engineers. They took every concept that came before, Mesopotamian codes, Egyptian fairness, Greek juries, and systematized it into something recognizable to any law student alive today. Roman courts introduced professional advocates, what we now call lawyers. They introduced the concept of legal precedent, using past rulings to guide new ones. They created the idea that the law applies equally to everyone, even, in theory, to emperors. The 12 Tables of Rome, written around 450 BC, were displayed publicly, just like Hammurabi's stele, so every Roman citizen could know the law that governed them. And it was Rome that gave us the word judge itself. The Latin iudex, meaning one who speaks the law. Every time you say judge, you are speaking Latin. Rome's legal innovations were so influential that when the Roman Empire collapsed in 476 AD, its legal DNA survived, absorbed into the Catholic Church, into European kingdoms, and eventually into the legal systems of nearly every country on Earth. Now, we are midway through this story, and it is about to get even more fascinating. But before we go further, if you have learned something new today, do something extraordinary. Share this video with at least one person. Not because we asked, because knowledge, freely given, is one of the most powerful things one human being can offer another. Hit the like button below. Subscribe to The Fascinating Origin of Things. Done? Let's continue. When Rome fell, the carefully constructed legal world collapsed with it. What replaced it was something far more terrifying: trial by ordeal. In medieval Europe, if you were accused of a crime, you might be forced to carry a red-hot iron bar for 3 paces. Your hand would then be wrapped and examined 3 days later. If it had healed, you were innocent. God had protected you. If it was infected, you were guilty. God had spoken. Other ordeals included being thrown into a river with hands and feet bound. Float? Guilty. The pure water had rejected you. Sink? Innocent. Though often, drowning became the price of innocence. These were not fringe practices. They were the official legal procedure of kingdoms across Europe for hundreds of years, sanctioned by the Church, overseen by priests. It was only in 1215, at the Fourth Lateran Council, that Pope Innocent III finally banned clergy from participating in ordeals. Almost overnight, trial by ordeal collapsed. And into that vacuum stepped something new: the jury trial. In England, the Magna Carta, also signed in 1215, planted the seed that would grow into the modern legal world. For most of human history, judges were not trained professionals. They were priests, or kings, or powerful landowners. The idea that a judge should have formal legal education, that judging was a skill to be learned, that was a radical idea. England's Inns of Court, established in the 14th century, were among the first institutions to train lawyers and judges as a distinct profession. Students would live, eat, and argue law together for years before being permitted to practice. The iconic white wigs that British and many Commonwealth judges and barristers still wear today? They trace back to the 17th century, when wigs were fashionable among European nobility. Judges adopted them as a mark of distinction. When wigs went out of fashion for everyone else, judges kept wearing them. As a symbol of authority, of timelessness, of the law standing apart from fashion and politics. When the American founders sat down to build a new nation, they made a decision that was, at the time, radical. They created a court system that was independent from the executive and legislative branches of government. No king, no parliament, no president could tell judges what to decide. The judiciary would be its own branch of power, and its highest court, the Supreme Court, would have the last word on the meaning of the Constitution itself. The first Chief Justice of the United States was John Jay, appointed in 1789. The Supreme Court, in its earliest years, was so new, so untested, that the justices actually rode horseback across the country to preside over circuit courts, literally bringing justice to the people. But the moment that truly defined the American judiciary came in 1803, a case called Marbury versus Madison. Chief Justice John Marshall established the principle of judicial review, the power of the Supreme Court to strike down any law passed by Congress if it violated the Constitution. That single ruling gave courts a power unlike anything seen in history. Not the power of the sword, not the power of money, but the power to say, no, this law is wrong, and it shall not stand. Today, nearly every nation on earth has its own system of courts and judges, but the philosophies behind them are fascinatingly different. In Japan, courtroom proceedings are famously methodical. Conviction rates exceed 99%, not because of corruption, but because prosecutors rarely bring cases they are not absolutely certain of winning. In India, the Supreme Court hears more cases than almost any other constitutional court in the world, serving over 1 billion people in a country with 22 official languages and centuries of legal tradition layered beneath it. And in The Hague, Netherlands, sits the International Court of Justice, the World Court, where entire nations face each other across a table, and a panel of 15 judges attempts the most difficult task in human history: delivering justice at a global scale. For 5,000 years, courts and judges have evolved to meet the changing demands of civilization. And now, at the edge of artificial intelligence, they face their most profound challenge yet. Several countries are already experimenting with AI-assisted sentencing tools, algorithms that analyze thousands of past cases and predict the likelihood of reoffending. Proponents say it removes human bias. Critics argue it encodes historical prejudice into code, and that no algorithm should replace human judgment in matters of life and liberty. China has gone further, piloting internet courts, where AI judges handle low-level disputes online in minutes. The questions that raises for due process, for the right to a human hearing, for the very soul of justice, those questions have no easy answers. But here is what history teaches us. Every time courts faced a new crisis, the fall of empires, religious wars, revolutionary upheaval, they adapted, they bent, and they survived. Because the need for justice, fair, impartial, accessible justice, is one of the most enduring needs of the human soul. From a Sumerian clay tablet to a Babylonian stone pillar, from Socrates standing trial in an open marketplace to 9 justices in a marble palace deciding the fate of a nation. Courts and judges were born from our oldest fear, that without structure, without accountability, without someone to say, "This is not right," humanity would devour itself. And in many ways, that fear was correct. But courts were also born from our oldest hope, that there is such a thing as justice, that fairness is possible, that one day, no matter who you are, powerful or powerless, rich or poor, famous or forgotten, you can stand before a tribunal of your peers, and the truth will matter. We have not always lived up to that hope. History is full of courts that failed, judges who were corrupt, and systems that protected the powerful at the expense of the weak. But the ideal has never died. And perhaps that is the most fascinating origin of all. Not the laws, not the courtrooms, not the wigs or the gavels or the Latin phrases, but the stubborn, ancient, deeply human belief that things can be made right. If this story moved you in any way, if it taught you something, or just made you see the world a little differently away, that's what the fascinating origin of things is here for. Subscribe so you never miss one. Share this video with someone who loves history. And drop a comment below. What origin story do you want us to explore next? Until next time, keep asking where things come from. The answers are always more extraordinary than you imagine.